Hello and good afternoon. Today we're talking about Title IX training for faculty and staff. This is the second time I've done this presentation for your campus. So if you came the first time and you're back for more because you have questions, as Lance said, please don't hesitate to put those in the chat, and I'm happy to answer things either as we go along, or if you just have some more general questions about Title IX, I'm happy to answer those or to kick them over to Lance if it's a policy-based question. So hoping that at the end of today, you will understand what behavior is prohibited under the sexual misconduct policy on your campus, how and when to make a report of prohibited conduct, and what happens when reports are made. I find that especially when folks have reporting requirements, they often feel a lot of anxiety about making those reports, knowing that the things that they say may, change the course of someone's life, right? You're making a big impact on them one way or the other. And so this training is hopefully going to help guide you in understanding what happens once those reports made, so that you can see that there's still a lot of autonomy, even if you're making a report on behalf of another person. So hopefully that helps you as you work through that situation. So today's agenda, we're going to talk first about the scope of Title IX. We're going to talk about what conduct is prohibited under your policy, how to report any concerns you may have, and then we'll talk about, again, what happens after that. So what does intake look like? What kind of supportive measures do we offer to the parties that are involved in these cases? How are formal complaints handled in terms of investigation and adjudication? And then also, how can you help on your campus to make sure that we are doing the right things and trying to create an environment that's really appropriate for all our campus community members? So first, let's start with the law. Title IX law is actually very short. There is a little bit more that comes after this part of the statute that talks about certainly exceptions, fraternities and sororities and things like that. But the basics of the law is just this paragraph here. So no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Since your college allows students to access federal student aid, then you are one of the colleges that Title IX applies to. You have a policy that applies to your campus. It's the policy on sexual misconduct. There is a link there on the slide. And so I would encourage you to read that if you never have. It is dense, as most Title IX policies are, but there's a lot of really important information in that policy. So please don't hesitate to reach out to Lance if you have questions about the policy, because he can answer those for you. This policy is going to include information that is both Title IX and non-Title IX conduct. Oh, I'm so sorry. I thought I was sharing my screen. Yes. Oh, am I sharing my screen? Give me a thumbs up.
Yes, I see it.
Okay, perfect. For some reason, I thought I wasn't. All right, good to go. All right. So we have both Title IX and non-Title IX conduct that is covered by the policy. And that's because Title IX, as a federal law and set of regulations, prescribes very closely what is prohibited by Title IX. But that being said, there's other types of sexual misconduct that are still not appropriate to happen on your campus. And so we don't want to limit it to just what the federal law requires. We do have more types of behavior that are included in this policy. So just know that if you went to go read the Title IX regulations, you may think, wow, this is pretty narrow. Your policy is not nearly as narrow. Also know that sexual misconduct does cover discrimination and harassment on the basis of sex. And for purposes of your policy, sex is defined as including sexual orientation, gender or gender identity, including transgender status, pregnancy, childbirth, and related medical conditions. It does protect pregnant individuals. So pregnant individuals at your campus are protected from discrimination by Title IX. So any individuals that are experiencing pregnancy, childbirth, or some medical condition related to pregnancy or childbirth can access reasonable accommodations and academic adjustments. Think of it as sort of like the process for getting disability services. I have a situation, it requires some assistance to continue to allow me to come to class or come to my job and do the things I need to do. And so this process, even though pregnancy or childbirth obviously is not maybe a lifelong situation, although having been pregnant, it may seem like a lifelong situation, there are those options for getting those temporary accommodations in place. And if that's the situation on your campus, students may seek those through the Office of Disability Services. and employees can seek those through the Office of Human Resources. So please don't hesitate if you or a person that you know may need those accommodations to go and seek out the correct resources. Title IX coordinator can also help. So if you have a situation where someone is pregnant or experiencing childbirth or a medical condition related to those things, please don't hesitate to reach out and ask Lance. And if you're not sure of where to go, Lance can help you with that. So I know some folks have gone through a little bit of a head spinning training session this year, right? So we started off the beginning of this year thinking that we were going to be under 2024 Title IX regulations. They had been put in place by the Biden administration. And so there was lots of training at the beginning of the year saying, okay, we're going to implement these new 2024 regulations. Well, then in January, we got news that the 2024 regulations had been invalidated by the courts. And when we pulled back the 2024 regulations, we went back to the 2020 regulations. So if you think about what your training was in 2023, that training is still correct. And we kind of just have a little bit of a hiccup with the 2024. So I'm going to try to explain the pregnancy regulations to you and the policy requirements, because you may have heard some things or remember some things from past trainings. And I just want to make it a little bit clearer to you exactly what applies now versus what you might have heard under the 2024 regulations that does not apply. So 2024 regulations, what they did with pregnancy and lactating students was they took a lot of guidance that had been issued by the U.S. Department of Education over many years, and they put it into the regulations really to make it easier to find. And there were some things that they did that went beyond the guidance, but largely a lot of what they put in the 2024 regulations was something that most campuses were already doing as a result of the guidance. So when we're rolling back the 2024 regulations to the 2020 regulations, those 2020 regulations did also provide protections to pregnant individuals. So this language, I don't want to go over it in great detail because it is not in effect, but it did provide that same sort of access to services and supports that might help a pregnant student get through their educational program to the extent that they can, even as they're pregnant, even as they're experiencing childbirth. I love this. Access to a larger desk or a footrest is one of the things that they suggest might be appropriate to pregnancy, and I can remember that very, very well. All right, also not in effect. Pregnant students are entitled to leaves of absence. You may say, wait, that's not in effect. Don't worry, don't worry. This is just of the regulations that are no longer in effect. We're going to see the 2020 regulations, and you'll see that all of this is pretty much live and well in terms of what we still provide for students. So let's see what's in effect in 2020 regulations. We do say pregnant students are protected from discrimination based on pregnancy, childbirth, termination of pregnancy. Note that doesn't say whether it's voluntary or involuntary, or recovery from any of these conditions, meaning schools must allow them to take medically necessary leaves of absence without penalty, return to their previous academic status, and receive reasonable accommodations to fully participate in classes and extracurricular activities as needed, similar to how they would accommodate temporary disability. This includes excused absences from medical appointments and the ability to make up missed work. So think of pregnancy as like someone has a medical issue that is going on for 6 months, and they may need some accommodations to get them through that, but we're going to be able to do that. Maybe it's something even more temporary. Maybe it's the type of things that you would provide to someone who had COVID or some other illness that became serious, right? We're involving missing classes and doing kind of needing multiple things on a regular basis. So that is what we are providing under the 2020 regulations. This is also still in effect. Schools are not allowed to discriminate against a student based on their pregnancy status. They can take that leave of absence for pregnancy-related medical needs without academic penalty. They have to return to their previous status. And again, we have to provide those reasonable accommodations, modified class schedules, breaks for medical needs, or access to alternative learning methods. So sometimes this looks like, gee, I need to be able to go use the restroom in the middle of a class or the middle of an exam. Sometimes it means that class schedules need to be changed or modified to make sure that students can get what they need to do. Remember, the goal is to allow the students to continue to make progress in their education, right? We want to continue to help them to the best we can on their journey towards getting a degree. And sometimes this can be easier to accommodate than other times, right? So if a student goes out at the beginning of a semester and they need to take maybe 6 weeks because of medical leave, it may be difficult, particularly if they're like a nursing student or something like that, where they have specific things they have to meet for licensure and do clinical placements and things like that. On the other hand, we may have a lot of flexibility, and we may be able to do that within our policies by providing some modifications. So that's something that, again, those offices on your campus can work with students on. In 2024, you may remember getting trained that all employees had to provide information to students. As soon as they found out they were pregnant, they had to either provide a notice of their rights, or they had to immediately contact the Title IX coordinator upon being informed by the student that they were pregnant. I always thought this was a little bit of an odd situation. It's like, hey, guess what, professor? I'm so excited, I'm pregnant. Well, here is your notice that I am mandatorily required to give you, right? So now you can just go back to being happy for people. There's no more mandatory reporting for pregnancy under the 2020 regulations. But of course, if you notice that a student would benefit from the information about where they can go for accommodations, please don't hesitate to give them that information. You can point them to the policy, or again, point them towards Lance to answer any questions. All right, so now that we kind of have an idea of pregnancy-related resources on campus, let's talk about the themes of Title IX. So Title IX was enacted to ensure equitable access to educational programs and activities regardless of sex. In other words, we're going to leave sex kind of at the door. We're going to be able to continue to come into our classrooms. We're going to continue to participate in our educational activities regardless of sex, and also regardless of some of the sexual misconduct that we might be experiencing. We want to make sure that students are still able to come through the door. And Title IX also applies to employees, so it's the same sort of situation with employees. We want to make sure that we are giving them equitable access to participate in our programs and activities. And just a moment to step back for a second. What is an educational program or activity? It is anything that your college does at all. So when we talk about educational programs and activities, it's not just the classroom environment, it's also extracurricular activities. It's anything that your students do on campus, but it's also anything your employees do on campus. So if you've got a payroll department that doesn't really talk to students, they just deal with payroll, and they're more involved in employees, that is still part of the education programs and activities of your institution. So Title IX applies to everything your institution does, and that's where we want to make sure there is equitable access regardless of sex. We also, under Title IX, want to work to protect our campus community from experiencing prohibited conduct. And we want to support the parties through the process. So if someone does experience prohibited conduct, we're going to try to provide them with supportive measures that they can use to continue to do the things they need to do at your institution. But likewise, if someone is accused of prohibited conduct, we don't know whether they've done anything or not yet. We haven't done an investigation. We haven't had a hearing or adjudicated the matter. And therefore, we're kind of withholding judgment, right? The criminal equivalent is innocent until proven guilty. It's sort of like that under Title IX too. The respondent is not presumed to be responsible for misconduct until we've gone through that process. So we continue to try to support the parties through the process with counseling and other supportive measures that we're going to talk about when we get a little further into the presentation. We also want to make sure that our process is transparent. Listen, if you are a party going through a process, you want to know what is happening now and what is happening next, and you want to know that the college isn't just making it up as they go along. There's a policy. We're following the steps in the policy, and if you want to know what happens next, you can always ask someone who works on the Title IX office, or you can look at the policy and see, there it is right there. That's what we're going to do next. So we want to do that in terms of transparency, to, again, encourage participation in the process, but also to reduce that stress and anxiety that comes around participating in a process like this. And when parties trust the process, they also tend to trust the outcome, even if it makes them unhappy. Maybe they say, oh, gee, I feel like I lost my case. But if they feel like they're being heard and that the process was transparent, a lot of times that means that they will be satisfied even if they are not entirely happy. All right, and we've talked about the last thing there, that we don't know what happened or whether it violated the policy until we make that decision by following our process. And that is something that we want to do and stay true to. I am often at different institutions called to be a hearing officer, and I have to make the decision on sometimes very difficult decisions about who is telling the truth and whether there was any violation of the policy. But I know if I follow the policy, I follow the procedures, and I apply the standards that are there, I can sleep at night with the outcome, because that is what the policy provides. And I hope to provide that same sort of certainty for the people involved in the process. One thing to know about your policy, and in every Title IX situation, we use the policy language to talk about things and not criminal law. So the policy uses complainant to describe the person to whom the bad things were reported to have happened. You may also call them a victim if you're in a law enforcement situation, or maybe a survivor. Those are things that if you start calling a person a victim or a survivor, it looks like you've already made a decision that they are in fact a victim or a survivor. And again, the college isn't allowed to make that decision until we've gone through the process. So we typically don't use those words. We stick to the policy language, which doesn't tell us whether they are or not someone who has experienced something that may be violating of the policy. We also have the respondent. That's the person who reportedly did the bad things to the complainant. Again, we don't use the word perpetrator because as soon as we label someone a perpetrator, it looks like we've made up our decisions before we've even finished the process. So want to keep people engaged in the process, we use the policy language. We also use the terms responsible for a policy violation or not responsible for a policy violation. We don't talk about being guilty, not guilty, innocent. That's for the criminal courts. Now, I did want to flag there is one part of your policy where we do use the term victim, and that is because it is drawing the language from federal law. So if you see that there, just know that it's from federal law, but otherwise we call everyone complainant or respondent. So what does the process look like? So the first thing that happens is the college receives a report. Someone sends Lance an email and says, hey, I just became aware of this. I wanted to let you know that, let's say, Bob, the kind of ubiquitous student, may have experienced some prohibited conduct. Okay, great. So Bob may be a complainant. We don't know if Bob is a complainant. We don't know if Bob would think of himself as a complainant, but we've got the report saying that something may have happened to Bob. The next thing that happens is intake. We're going to reach out to Bob and say, hey, Bob, we've heard you may have experienced some prohibited conduct. We want to make sure you know your options, and we want you to be able to get support if you want to. Very easy contact. This is not, Bob, you will show up in my office at 3 o'clock on Thursday. This is, Bob, we're here to help. Here's how we can make that happen, right? So if Bob wants to come in, we can do an interview to discuss the options. That includes just seeking confidential resources like counseling. Maybe Bob wants to go to law enforcement if the allegations involve potentially criminal conduct. Maybe Bob wants to do the college process. Bob can do both of those things. Bob can do neither of those things, or one and then the other, or vice versa. Bob has a lot of options here. And of course, confidential resources are available to Bob at any point in time. If Bob decides, hey, I want to go forward with the college process, then there's something filed called a formal complaint. And the formal complaint is something that makes it clear to the people involved in the process exactly what the allegations are going to be. And the formal complaint says, hi, I'm Bob, and I want this claim to go forward. So there are two things that can happen to that. One is informal resolution, where maybe the parties agree they want to come together and figure out how to move forward and reach an agreement. It's literally a written agreement about what will happen. If they get an informal resolution, that's wonderful. Then the case is resolved. We don't have to go through the rest of the process. But informal resolution may not always be available depending on the circumstances. It may be that the case goes through investigation and adjudication, which involves a hearing. Once we get to the end of that, then we have a decision as to whether the respondent has violated a policy. And that's the point where if that's the case and the policy was violated, we can issue disciplinary sanctions. All right, so what is prohibited misconduct? How do we know what falls under this process? So these are the titles of the things that are prohibited in your policy. So dating violence and domestic violence, often together referred to as intimate partner violence. We also have sexual assault contact and sexual assault penetration, sexual harassment, stalking, Title IX sexual harassment, which means that some of these things that I've just mentioned happened, but also they happened in the context of an educational program or activity, and also in the United States. So there's a little bit more limitation to what is considered Title IX sexual harassment, against that narrowing by the regulations that I talked about earlier. And then voyeurism. So these definitions are taken directly from your policy, which again, Lance dropped into the chat earlier. So what does it mean? Dating violence is violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. And this is basically violence plus relationship. Was there violence, and are you dating? Dating can be difficult to figure out these days. People are interacting with each other in ways that 20 years ago they weren't. So if I have a snap streak with someone, or if I've communicated with them regularly on Tinder, but we've never met, Does that equal a dating relationship? So when the parties don't agree on that, we look to the length of the relationship, the type of the relationship, and the frequency of interactions between those people in the relationship. And it can be romantic or intimate without being sexual. So maybe people haven't gotten to a point in the relationship where they're actually engaging in sexual activity, but it still may qualify as dating for the purpose of violence plus relationship. This can be a single act or a pattern of behavior, and you can look at the frequency, nature, and severity of the conduct, and it also includes the threat of sexual assault or physical abuse. So that's dating violence. Domestic violence is also violence plus relationship. Here, it requires a little bit more of a tight relationship. Dating, a little less dependent on each other, but domestic violence requires a relationship where they share a child in common, they cohabitate in the form of intimate partners or spouses, or they're similarly situated to a spouse. It also includes acts against an adult or youth victim who are protected from that person's acts under the applicable domestic or family violence laws. So, and this is a felony or misdemeanor crime of violence. So a little bit more specific on the type of violence, a little bit more specific or elevated type of relationship. And again, just like dating violence, it can be a single act or pattern of behavior based on the frequency, nature, and severity of the conduct. In terms of sexual assault contact, it's any sexual contact, including sexual touching for the purpose of sexual gratification of either party, or degrading or abusing such person without that person's consent. And we're talking about contact under or over the clothing with another person's anus, breast, buttocks, genitals, groin, or inner thigh, touching another person anywhere with any of those body parts, making another person touch any of these body parts under or over clothing, or the emission of ejaculate on the clothing or body of another person. So if any of those things happened, it would be considered potentially sexual assault contact under your policy. Sexual assault penetration involves, not surprisingly, penetration. So any form of vaginal, anal, or oral penetration or attempted penetration, however slight, by a penis, object, tongue, or finger without a person's consent. This also includes incest and statutory rape. Incest is the sexual conduct between two people for whom marriage is not allowed by law due to familial relationships. And then statutory rape involves having sexual relations with someone who is under the age of consent. Sexual harassment. Sexual harassment, I do see a comment in the box. I will get to that in just a little bit. So sexual harassment is unwelcome verbal or physical behavior based on a person's sex, including sexual orientation, gender identity, gender expression, gender, including transgender status. The conduct is considered unwelcome if the individual did not request or invite it, and consider the conduct to be undesirable or offensive. And this includes unwelcome conduct when either we have a quid pro quo situation or a hostile environment situation. So the quid pro quo means an employee has to be the respondent. So an employee of the college conditions the provision of an aid, benefit, or service on an individual's participation in unwelcome sexual conduct. Or the hostile environment piece is such conduct alters the conditions of or has the effect of interfering with an individual's educational or work experience by creating an intimidating, hostile, or offensive environment. And that is evaluated based on the perspective of a reasonable person in the position of a complainant. There, in your policy, there is a list of examples of things that constitute sexual harassment. But know that in evaluating these things, it's literally a hearing officer is going to look at the behavior that is determined to have occurred and say, okay, is it unwelcome? Is it verbal or physical? Is it based on the person's sex? And then does it rise to the level of either quid pro quo or hostile environment? Stalking, another portion of your policy, is including engaging in a course of conduct directed at a specific person that would cause a reasonable person to either fear for their safety or the safety of others, or suffer substantial emotional distress. And this policy is pinned to stalking on the basis of sex, sexual orientation, gender expression, gender identity, including transgender status. Other stalking is not allowed. If you're being stalked because a student doesn't like their grade or because you owe someone rent money, right? Those things are still not okay. We don't engage in stalking, but this policy only deals with it if it's based on sex. All right. I mentioned that Title IX had narrowed what is considered Title IX sexual harassment. This is the definition of Title IX sexual harassment. So it's conduct on the basis of sex, as we've defined sex, that occurs in your education program or activity against a person in the United States and that satisfies one or more of the following. So the first one is the hostile environment piece, an employee conditioning the provision of an aid, benefit, or service on an individual's participation in unwelcome sexual conduct. The second is that hostile environment standard. Unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to your university's education program or activity. And remember that the previous definition of sexual harassment did not have this language of severe, pervasive, and objectively offensive. So we are taking a higher standard for sexual harassment to get to Title IX sexual harassment. And the third bullet point there is it's Title IX sexual harassment if it meets the requirements in that umbrella paragraph, and it also constitutes sexual assault, dating violence, domestic violence, or stalking as defined by the policy. We also have voyeurism, that's unlawful surveillance. It includes acts that violates a person's right to privacy in connection with their body and or sexual activity. This is the hiding in the bushes, looking in the windows, when someone is undressing, that sort of behavior. It can also be putting sexual conduct on the internet or taking videos or things of that nature when someone is not aware that that's happening. All right, we did have a question about what happens when we have online classes and someone shows up naked. Well, the answer is it's gonna be something that you should report to the Title IX coordinator, and the Title IX coordinator can work through this process, because part of this process to determine, does the behavior constitute something that could violate the policy? And if so, who is the respondent in that situation, right? So there's a lot of complex things that need to be worked through. And if that is the situation, you can report it, and then the Title IX coordinator can figure out what needs to happen. And it may be that there can't be anything done about that particular situation, or maybe there is something that can be done. Either way, there may be supportive measures available for the people in that situation. All right, some other relevant definitions involve consent. So we talked about unwelcome conduct, right? Well, what does it mean to be unwelcome? It's without consent, right? And we also talked about this in the terms of sexual assault, right? With sexual touching or sexual penetration without consent. So your campus uses this standard. Its affirmative consent is knowing, voluntary, and mutual decision among all participants to engage in sexual activity. And it can be given by words or actions, as long as those actions create clear permission regarding willingness to engage in the sexual activity. So, and know that the person doing the thing is the one that is required to get the consent, right? Or the person initiating the thing is the one required to get consent. Silence or lack of resistance in and of itself does not demonstrate consent. So I hear a lot of cases, and sometimes the response by the respondent will be, well, I did this thing and they didn't say no, and therefore I assumed I had consent. And if that's all they have to show consent, your policy makes it clear that that is not sufficient from a consent perspective. Note that this definition doesn't vary based upon the participant's sex. So this applies regardless of whether the complainant or respondent is a man or a woman or some other gender. All right, also in your definition of consent, consent to any sexual act or prior consensual sexual activity between or with any party does not necessarily constitute consent to any other sexual act. So in other words, oh, we're dating and we had sex yesterday does not mean you automatically have consent for the rest of the relationship. In the same way, if one person consents to kissing, it does not mean that they have consented to penetrative sex. So consent must be obtained for each individual act on each occasion that the act occurs. In order to give consent, one must be of legal age, which in New York is the age of 17 or older. And consent is required regardless of whether the person initiating the act is under the influence of drugs and or alcohol. So I would say it's not a get out of jail free card. If you are really, really drunk when you are initiating the sexual activity, you are still charged with getting the consent of the other party. Consent can sometimes be given, but then withdrawn later. And that is an okay thing. We have to have the autonomy to say, you know what, I want to stop. So it can be withdrawn at any time. And when it's withdrawn or when it can no longer be given, sexual activity must stop. So in other words, if somebody says, stop, I don't want to do this anymore, that would be a withdrawal of consent and it needs to stop immediately. But also if that person should fall asleep or pass out and otherwise be unable to continue the consent, at that point the sexual activity must stop. If someone is incapacitated, they also are incapable of giving consent. So that incapacitation is reached when an individual lacks the ability to knowingly choose to participate in sexual activity. Usually it means that the person is unconscious, asleep, or they may be intoxicated due to drugs or other alcohol, other substances that may put them in a place where they just don't understand what's happening and therefore can't really knowingly choose to participate, right? So it can also be if you are involuntarily restrained, all of those situations can result in incapacitation. And it's a high bar. It's not just, I had a drink of wine and therefore I am incapacitation, because intoxication is not the same thing as incapacitation. When I'm intoxicated, I may feel buzzed, I may feel happy, I may do things that I wouldn't do if I was completely sober. But incapacitation means I really can't, I'm not in a state of mind where I understand what's happening to the point that I can give informed consent. And so it is a lot more than just the glass of wine you had with dinner, typically. So consent can be given, but it's not valid when the person is incapacitated or when consent results from coercion, intimidation, force, or threat of harm. So if someone says, if you don't consent, I'm going to kill myself, that would be coercion, right? So in that situation, we can't really consider that the consent was given voluntarily, because the alternative is that someone dies, right? So we want to look for those sorts of situations. Now, sometimes there get to be some concerns about students. They'll say, well, I was told if I didn't have sex with them, they were going to break up with me. That may look a little less like coercion, right? Like the people are allowed to have restrictions on who they want to have relationships with, and if that's a deal breaker, that might be a deal breaker. It doesn't make the sexual activity necessarily sexual assault, right? So coercion, again, it's a bit of a bar to reach. We want to make sure that we are keeping people from doing things that are unreasonable in the context of soliciting consent for sexual activity. We also have other types of prohibited conduct on their policy. That includes retaliation, knowingly submitted false statements or information, and then certain intimate relationships between students and faculty members or employees. You will want to read each of these things, particularly the third one, just so you know what the standards are on your campus. Retaliation to me is the most important of these three, because if we have people retaliating against each other because they have participated in a process to adjudicate sexual misconduct, maybe they made a report, maybe they participated as a witness. In those situations, our process, we want to maintain the integrity of the process. We want people to participate and engage, and if they feel like they can't because they have been intimidated or harassed, that can constitute retaliation. So that is taken very seriously. If that is a situation that you experience or you know someone else is experiencing, please tell Lance right away. Last but not least, sex discrimination is also prohibited, but that is not covered by this policy that we're training on today. It's covered by the equal opportunity and non-discrimination policy. So please don't treat people differently on the basis of sex, but know that that is handled through a different process. All right. So we know what prohibited conduct is now. So what do we do when we want to make a report? So if you believe that you personally have experienced prohibited conduct, you have options that are available to you. You can speak with a confidential resource. You can seek law enforcement assistance if the conduct was criminal, and you can talk with Lance to get more information about your options, either under the process or to get resources and supportive measures. And you can also make a report through your university-wide discrimination and retaliation reporting portal. So the policy has more information on all of these options that are available to you, and you can absolutely go and check that out. The link has been dropped in the chat. So if you personally have experienced the conduct, you are encouraged to report it. But as a complainant, you have autonomy to decide what you want to do with your own experience. So we're not requiring you to report prohibited conduct that you personally experience, because that would be a violation of your autonomy. We want to give you those options. You can come in and still encouraged to come in and get supportive measures, even if you never want to go through a process. Now, if it is not conduct that was directed at you, you may be a responsible employee that has an obligation to report to the institution. And I'm going to give you the list of responsible employees in a few minutes. So we'll just hold off on that. So those folks are required to report allegations of prohibited conduct of which they become aware. Now, note, I didn't say they have to investigate it to determine whether it might really be real before they report it. That's not how this works. Report it and take that burden off your shoulders and give it to Lance, and Lance is going to handle it. Okay. So responsible employees, you make the report with what you know. You don't have to what I call Scooby-Doo it yourself to conduct your own investigation. And then Lance will take it from there. If you are a confidential employee, you are not permitted to report information that is learned in the scope of that confidential relationship unless you have permission from the person that gave you the information. So if you're a counselor or some sort of medical practitioner, or maybe a pastoral counselor, and someone comes into you during a counseling appointment and says, hey, I experienced prohibited conduct, you don't have to report unless there is an imminent threat of serious serious injury to the reporter or another person. In that case, you may have to break confidentiality for safety reasons. But if that's not the situation, they're saying this thing happened to me, I just want to talk about it in my counseling appointment, you are not required to report that to the Title IX office. But note, it may be helpful for you to understand the process so that you can give them some contacts if they're interested, to get supportive measures through Lance's office. All right. So what is the reporting difference under 2020 and 2024? There were different reporting requirements, and generally more people were required to report under the 2024 regulations. But again, that has been rolled back. So under 2020, we are back to the responsible employee category. And so that's the key term that we're going to be using. So this is what is not in effect. It had all kinds of information about what was your role at the institution, what authority did you have, and that's how we figured out who had to make a report. Forget all of that stuff, not applicable anymore. This is what we have. So if you're designated as a responsible employee, I think that's on the next slide, you have the duty to report allegations, including all relevant details, to the Title IX coordinator. You are not permitted to maintain a complainant's confidentiality, but you maintain their privacy. In other words, don't walk all over campus saying, hey, you'll never guess what Bob told me, right? Like, that's not a good plan. And nobody's going to trust you again. Like Bob's friends are not going to come towards you if they understand that you've been spreading rumors about Bob on campus. So we're going to keep it private in that we're only telling people that really need to know, like the Title IX coordinator. Title IX coordinator will then make it very clear as they handle the case, who needs to know, who doesn't need to know, and they're only going to share information as necessary. This also says that before a complainant reveals information to you, if you're a responsible employee, you should let them know, hey, I'm a responsible employee. If you report any sexual misconduct to me, just know that I have to make a mandatory report. If you don't want to do that, if you don't want me to make a mandatory report, then it might be better not to tell me, but you might consider contacting a confidential resource. Counseling, there's a list in the policy, and Lance can also provide you with information about confidential resources. All right, so who is a responsible employee? This is the official list. So you'll note some of the bigger ones I have highlighted or I have bolded. So all staff housed in the Student Affairs Office or the Dean of Students Office, all your residence life staff, including your RAs, your HR directors, deputy directors, athletics staff, this is all responsible employees, department chairpersons, faculty and staff members are responsible employees when they're leading or supervising students on off-campus trips because they're kind of in the role of the supervisor there. So these are the folks. Managers and supervisors are also considered to be responsible employees if someone who reports to them makes a report of prohibited conduct to them. So that last bullet is very important. So hopefully you can look at this list and determine whether you fall into any of the categories and know whether you are a responsible employee. And if you're not sure, send Lance a message and ask, and he can give you some guidance on that. All right, so if you are a responsible employee, what is your duty? You must report all known information regarding potential prohibited conduct. You make it in writing to the Title IX coordinator. You have to give your name because that's how we say, yep, they made their mandatory report. You have to give the complainant's name and the respondent's name if you know it, because again, all known information must be reported. Those are usually the questions I get asked from folks who are a little bit worried about making their complaints. So what if the prohibited conduct happened a long time ago, or didn't happen on campus, or involves misconduct by someone who graduated already, or maybe they don't work here anymore, or it constitutes child abuse and the person is now an adult, or it involves someone that you just know could not possibly have done this? Listen, I have heard it all. Just make your required report and let Lance deal with it. If it happened a long time ago, if that respondent's still on campus, it might happen again. If maybe we want to move forward and deal with it. If it didn't happen on campus, that doesn't mean that the person that experienced it doesn't need it to be addressed, either just through supportive measures or maybe there is a process that applies, right? If they've graduated already, well, maybe we go through the process to make sure that they don't come back to campus for anything, that they don't apply for a job here or re-enroll here, right? So there's always something that can be done, even in situations where like, I'm not really sure that this is something that's going to fall into it. Again, just make your required report. It's much easier if everyone does. So what happens when you make a report? So the Title IX coordinator is going to attempt to contact the complainant and offer support. And typically the email looks something like this, you know, hi, I'm the Title IX coordinator. I've heard that you may have experienced some prohibited conduct under this sexual misconduct policy. Here's a copy of the policy. I'm here if you want to talk about supportive measures and some options that may be available to you. And here's how you can schedule an appointment with me so that we can talk about it. If you need anything, let me know. See you later. That's it. That's typically what goes in these emails, right? And then the person can hold on to it. Maybe they never reply. And anecdotally, about 40% of the people that receive these emails across all of my clients, they just never respond to it. But I always like to think that it's there for them. So someday they may be in a headspace where they're like, now it's time. It's time to move forward. And look, they already have that information in their inbox and they know where to go. So I'm a big fan of these intake emails. And typically most campuses will only reach out, you know, maybe twice. And if the person doesn't want to talk, then that's okay, right? Why do we want to make sure that these reports are made? Number one, they may be at a point in their life where they've already told someone what has happened to them, right? There's already information floating out there. They may need support and don't know how to ask. So this just opens that line of conversation. Also, maybe you told them as the mandatory reporter, you might have told them about their options, but not everyone absorbs that information the first time they hear them. So sometimes just having that in writing again for the future may be really beneficial for them. Also know that when you make a report, it may be that the Title IX coordinator already knows about a situation. Maybe it's a related situation, maybe it's about this situation, but you may have some missing piece of the puzzle that helps to figure out exactly what to do to move forward. It might be the first piece of the puzzle, it might be the last piece of the puzzle. And the bottom line is, you know, Lance is trying to put together a puzzle that doesn't really have any, there's no picture on the box to tell him what it looks like, right? So when he gets different pieces and parts, that's going to be really helpful to figure out how to keep the campus community safe and make sure that people are getting the support they need. So I always like to tell people, just hand your puzzle pieces over so that someone who can see the bigger picture has them for when it's necessary. All right, so I mentioned earlier that if you're a responsible employee, you may want to tell somebody that. So I wanted to give you some language for that. So, you know, print the slide out, stick it somewhere in a drawer so that you have it when you're available. You can just say, I'm a responsible employee. It means if you tell me something about sexual misconduct, I'm going to have to make a report to the Title IX coordinator. That means they're going to contact you to see if you want to meet to discuss resources and options, but you don't have to meet. And if you don't want that to happen, then let's look at the list of confidential resources and see if that might be a better place for you to get support. So this is great. Sometimes people walk into your office, you've just got this gut feeling they're going to tell you something that's going to be sexual misconduct. There's your spiel right there. Sometimes they say it before you realize what's happening, right? So once they've said it already, you can't be like, sorry, I'm going to ignore that, right? We have to take action. So how do we tell them that we're going to make a report? You say, I'm a responsible employee, so I'm required to report this to the Title IX coordinator. The coordinator will contact you and ask if you want support or want to meet, but you don't have to respond. If you're really nice, you can add the third bullet point in. Do you want to be here when I make the report so you can get more information about your options while we're together, right? So maybe they'll just sit there while you type up the email to the Title IX coordinator. Maybe they will, maybe you can even, you know, call the Title IX coordinator and say, hey, I've got this situation. Do you mind if we come over to your office right now? And I've had that done, you know, particularly for folks who are, you know, responsible employees and they have a good relationship with the person. Sometimes the person really appreciates that extra touch. Responsible employee in terms of, so there's a question in the box. Responsible employee, is it preferable to designated reporter? Honestly, responsible employee is the term used in the federal regulations, and and your policy. So that's why I use it. Designated report, it really means the same thing. But if you're looking through the policy, like doing a search and find, and you're like, where's the designated employee piece? Well, you're not going to find it because they're going to use the term responsible employee. So all right, what if you are not sure about whether you should make a report? Two options for you. Number one, you can always call the Title IX coordinator and say, hey, I got this weird thing happening. I really don't even know if it falls under your jurisdiction at all, but I'm not sure whether I need to make a report. And the coordinator will tell you, yeah, you should definitely report that. Or you know what, it sounds like what you're describing is more under this other policy or this other thing, and that's where I would recommend you go. They can totally do that. It's a quick phone call, no big deal. On the other hand, you can also just make the report anyway, because if they get a report and they're like, this doesn't fall under my jurisdiction, it falls under this other policy or this other person, they're going to forward it there and it's going to get to where it needs to go anyway. So those are your options. Making the report anyway is usually the easiest thing to do, but it's up to you. All right, so what does it look like when somebody comes in for that initial discussion with the coordinator? So again, the coordinator is going to explain some things. I'm going to keep your information private. It's not confidential. I'm not a counselor, I'm not a medical professional where I have that privileged relationship. But as the coordinator, I'm going to keep things private. I'm only going to tell people the things that they need to know. I'm going to check and see, are you safe? Do you need supportive measures? Is there anything we can do to help make this easier for you as you try to figure out what you want to do? And then what are your options under the policy? You can report to law enforcement if it's criminal. You can report it to the college and we can go forward with the process. You can do both of those things. You can do neither thing. You can just kind of wait and see what you want to do. You can do one and then the other, or vice versa. There's really no set rules about this stuff. So you do have options and you can kind of consider what you want to do. And if you choose to make a report, you don't have to pursue a complaint right now. So in other words, a person can say, I want to tell you what happened. I want you to keep it on file, but I'm not ready to go through this whole investigation thing yet. I'm not in a place. Maybe I'm going to go talk to a counselor for 6 months and then I'll be ready to go through an investigation. That's fine. That's an okay choice too. What are some examples of supportive measures? These are pretty standard ones. No contact orders, don't talk to each other, move apart if you find yourself in the same place. Just kind of, it's the same thing I do to my kids when they're, upset about something. I'll say, hey, okay, let's take some steps back. Let's get some space here so that everybody can breathe and figure out what to do next. We offer counseling. You can get extensions of deadlines or other course-related adjustments, modifications of work or class schedules, campus escort service if there's a security issue and you need walked to your car, changes in work or housing locations, leaves of absence, increased security and monitoring of certain areas of the campus, and other similar measures. And you may think, what is that increased security? The example I always give is I had a campus where they seemed to have a lot of reports that centered around this one single-sex bathroom that was kind of tucked away in a building. And so they had a lot of activity in that bathroom that wasn't always consensual. And so they just started sending security guards past the bathroom every hour. And that seemed to reduce the safety issues, and there weren't as many problems after that. So, those sorts of things can be used to provide support and try to help people, again, be able to move through campus and do what they need to do. So they are kept confidential to the extent possible. If somebody says, gee, I'm living on the same floor or I'm in the same classroom as the person who did this thing to me, is there any chance I can change classes? Yes, you can, but we're going to have to tell the professor that you're going to be changing classes, right? We don't have to tell them why. They don't need all the gory details, but we do need to say, this is a real thing. It does need to happen. Let's make it happen. And so that professor is going to be aware of that, as is the new professor who's going to be receiving the student, right? Supportive measures are non-disciplinary and non-punitive. So we're not doing it to, go after the respondent, because again, we don't know if the respondent's done anything wrong yet at this point in the process. So we're just trying to give people enough space to do what they need to do. It's individualized. So if you come forward with a complaint, it's not like, here are the things that you get, period. And the party's wishes are taken into account. But, we also want to make sure that we're doing reasonable things. So I might find it a supportive measure. If I experience misconduct, if I say, what I really need is time to get away. Can you fly me to a beach for a week? That will make me feel better. And the campus can go, yeah, that's not what we're talking about. We're talking about how can we get you to show up to class without feeling unsafe, right? So supportive measures do have to be reasonable. All right. So let's say a party decides they want to move forward. They say, I want some sort of process. Well, now we need a formal complaint. So the complainant can choose to file one with the Title IX coordinator, and the coordinator can do that under very specific circumstances. And the formal complaint has to include the name of the complainant, a description of the prohibited conduct, a request that the college investigate, and the complainant's signature, which just means the complainant signs off on it. It could be an email that the complainant, sends, that sort of thing works too. Once a formal complaint is filed, then the coordinator decides whether informal resolution is appropriate to offer. So sometimes it is and sometimes it isn't, and there are rules about that that are explained in the policy. And if a formal complaint is filed but doesn't meet the requirements of the policy, the complaint may be dismissed and sent to another college process. So sometimes maybe the first thing that you hear about a case as a Title IX coordinator is a complainant reaches out and said, this is my formal complaint. Here are all the things that go in a formal complaint, and this is the terrible thing that happened to me. And the Title IX coordinator looks at this and says, you know what? This does not fall under sexual misconduct, but it does fall under roommate dispute. So I'm going to send it over to residence life, right? So it's dismissed from the process once we have a formal complaint, but it doesn't mean that we do nothing. We do something typically, but we want to make sure that it goes through the right process. If there's informal resolution, note, or that bottom bullet point is really important. The process is not available where an employee is accused of sexually harassing a student. That is supposed to make it to where the institution isn't putting pressure on the student to informally resolve something to protect the employee. So that's a really important limitation. When informal resolution is appropriate and it gets offered, then both parties get notice of the allegation, they get information of the process, they both have to voluntarily agree in writing to participate. And then typically what happens is there's a facilitator. The facilitator will go talk to the complainant and say, what do you need to be able to move forward here? What can we put in this agreement? And then go to the respondent, hey, this would work for them. Does this work for you? And what do you need to move forward? And we get to the point where we can get a written resolution of the case. If we can't resolve it through informal resolution, we're not going to do nothing. We're going to do an investigation. So let's talk about that. So what does an investigation look like? First off, both parties receive written notice of the allegation. That's really important. We don't do anything by ambush in a Title IX process, right? So everybody knows what we're investigating when we start the process. And the parties are going to get an opportunity to be interviewed by the investigator. They can provide a written statement. They can provide evidence, suggest witnesses and questions for those witnesses, suggest where evidence might be obtained, because ultimately it's on the investigator to collect the evidence. It's not a burden that the parties themselves have. Right, so the investigator is going to do all of the talking with people, collect all of the information, and that's really their job. And sometimes it may be collecting information that the parties don't even know exists. So for example, maybe as an investigator say, well, that happened in the lobby of this building, and I know there's a security camera and I can get that footage. Parties didn't ask you to do it, but as an investigator, that's going to be really helpful in this case, right? So investigator carries that burden. The investigator then puts together the evidence and lets the parties review it. I always picture it as picture a table that's set out for a banquet and all the evidence is set out on this table. The parties can kind of come and look at everything that's on the table and go, you know what, you're missing something. It's supposed to go right here. This witness would be really important. This evidence is something you might consider to collect. So we want to make sure that that table is as full as possible of relevant information. The investigator, once they get that feedback, they can conduct follow-up interviews or gather more evidence. Once they do that, they're going to prepare an investigation report that fairly summarizes the relevant evidence that's gathered. They're not going to make findings of fact. They're not making credibility assessments. They're not determining whether the policy was violated. They're just saying, this is the stuff I got. This is what we have to work with. And then those parties have an opportunity to respond in writing to that report. Then it gets sent to the adjudication committee, which is a panel of 3 people, and they are going to be working to resolve the case. So each party gets to work with an advisor of choice, and that person is basically the one who asks the questions at a hearing situation. So if a party doesn't have an advisor, the college does appoint one to assist to make sure that everyone has someone as an advisor in these hearings. And then the committee, it's up to them to make a decision whether a preponderance of the evidence established that a policy violation occurred. And a preponderance of the evidence just means, is it more likely than not that a policy violation occurred? If the answer is yes, then they also impose sanction. And all of that is written up in a detailed determination of responsibility, which will explain what facts were found, how are they applying those facts to the policy, what is the rationale for believing certain people over other people if there are credibility issues in question, what evidence did they weigh more heavily. All of those things are explained in the determination of the responsibility, and then the parties may appeal that determination. There's also a non-Title IX process. So Title IX sexual misconduct has that hearing. A non-Title IX process, the informal resolution is available. we still have an investigation that involves factual finding, credibility assessments, or whether there's a preponderance of the evidence that the respondent violated the policy, but there is no live hearing in this situation. So it's a little bit maybe less intimidating for folks, but I'll tell you, I've been doing hearings for a long time, and oftentimes they can be more efficient, and so they get folks through the process. So there's pluses and minuses for both. What is typically a non-Title IX process going to look like? The most usual reason that something is a non-Title IX process is because the conduct did not happen in the context of an educational program or activity. Maybe it was an off-campus apartment or something of that nature, and that's usually why something goes through the non-Title IX process. Or maybe it meets the definition under the policy of something that is non-Title IX, but it does not rise to the level of a Title IX sexual harassment that requires the live hearing. All right, so some notes about the process. The process is based on evidence. It is not about a gut feeling. It is not about statistics. It is not about how much this might impact a particular person's life. Because I'll tell you, if you're on this hearing panel and you say, gee, this is really going to affect the respondent if we find the respondent responsible for a policy violation and we have to expel them. And I'm here to tell you, if that's the situation, then I guarantee you that the complainant had some pretty serious impact too, right? So it's not a we're not using the end as a way to adjust the process. We are looking at the evidence, we are applying the policy to the evidence, and we are making a decision based on that information. And again, that respondent is presumed not responsible unless we have a preponderance of the evidence that demonstrates they are responsible for a policy violation. So how can you help on your campus? Number one, you're doing it right now. Actively seek training, set a good example, be informed about what the process is so that you can help connect people to resources and make sure that they can find their way. Recognize your role. You're not an investigator, right? So you don't have to investigate. You don't have to seek out more information. Make the reports if required. Put those on someone else's shoulders and know that you've done what you need to do. Be supportive of all individuals that are participating in the process. If you're teaching a class and maybe someone is a respondent who needs supportive measures, remember, they're all our students. We don't know whether that person has done anything against the policy yet. We may need to provide support to them too, because the hardest day in someone's life might be the day they're sexual assaulted, but the hardest day in someone's life might be the day they're accused of sexual assault that they don't feel that they've committed, right? Both of those things can be really hard. So we want to make sure that we are being supportive of everyone who's going through the process. Also be patient. Parties don't always make the choices you want them to make, right? So sometimes they say, you may think it's really serious conduct. I need you to move forward. I need you to file a complaint. And you want with every part of your soul for them to go through and address it, and they're just not ready. Well, listen, if we move forward to address it and they don't participate in the process, then they're probably not going to like the outcome. And now we've taken away their opportunity to choose when to do it. So we do want to, make sure that they've got autonomy when we can allow them to do that. And that may be frustrating. So just recognize that. Also, if you're providing supportive measures to anybody in your class because they have told you that they've experienced this conduct, just make sure the coordinator's in the loop, because part of the federal law requires the coordinator to keep track of what's been provided. Make sure we're not prejudging cases, claims, or people, and we are reporting that retaliation if it does occur. So if you need more information, again, here's Lance's contact information, and there's the link to the office, and we would hope that you would reach out if you have any more questions. We want to make sure that you have a resource for that. I also have a question about the key differences between the 2020 and the 2024 policy. I will tell you the biggest issue is that the 2024 policy changed the definition of sexual harassment. That is the biggest thing that happened, and it changed the process. So it was originally called sex-based harassment. Now it's sexual harassment back as it was under the old policy. And so that to me is the biggest change. So with that, I'm checking to see if we have any other questions, but that's the end of our slides. Lance, do you have anything to add?
I just want to thank everyone for attending. Again, I want to thank all of you for attending. I want to share one screen here for a moment. My contact information. I'm located over in the Cow Street building.
If you could scroll down, it's showing up as just a kind of weird strip on my screen to where I can't see your. There you go. There we go.
Okay. So I'm located in 1150 Cal Street Building, room C208F. My office line is 718-270-6169. My cell line is 917-921-9451. My email is lance.houston16@mac.cu.edu. Please feel free to reach out if you need further questions about this training or Title IX in general. Thank you so much for attending.